You're back in oil and gas with Professor Coleman, Energy Law Prof, and today we're talking about one of the most important rules in oil and gas, the rule of capture, the rule that says if you drill an oil and gas well on your land, all the oil that comes up from it belongs to you, even if that oil was originally sitting under your neighbor's land. Here is a case that is pretty much classic rule of capture. Kelly versus Ohio Oil. You can find it in your book on page 48. It's a case from 1897 in Ohio. In this case, the defendant allegedly put its oil wells right at the edge of plaintiff's land. And plaintiff says, obviously, you're trying to produce oil from under my land, and you should be liable for that because that oil originally came from me. The court refuses to protect the plaintiff because they say the rule of capture applies. And so what that means is, regardless of where that oil was originally sitting, if it was produced by a well on defendant's land, it belongs to the defendant. And you can think about one of the big advantages of this rule of capture is, as a result, when oil comes up out of a well, we don't have to decide where exactly that oil came from. Because even today, and certainly back then, it is sometimes difficult to say exactly where the oil and gas was lying under the ground that comes up at the wellhead that you end up producing. That's because we can't see perfectly under the earth. We don't know exactly where this oil is coming from, and that was certainly true in 1897. And so one thing that the rule of capture really did for the courts is it said we don't have to worry about where this oil is coming from. As long as it's produced by a well on your land, it belongs to you. Now, the rule of capture is limited in several important ways. And so mostly I want you to think of the rule of capture as sort of a default. We'll see lots of circumstances where there's limits on your ability to produce oil and gas from a well. But if there's no other limits from the state or otherwise, the background principle is go ahead and produce the oil and gas. If you produce it all before your neighbor gets around to drilling their own well, it all belongs to you. That's why the courts, when people complain about wells that they think are producing oil from underneath their land as well, the courts say your only solution, plaintiff, is go and do likewise. Go drill your own well and you'll have an opportunity to produce as well. So a couple limits that have existed ever since the start with the rule of capture. One is it doesn't authorize trespass. So of course you can't go onto your neighbor's land and drill a well. But you also can't drill what's called a slant well that would start on your property but angle underneath the earth until it passed through the property line, which again, under the ad coelum doctrine, we could imagine extending from the edge of the property to the center of the earth. So if you drill a slant well that crosses that line, you're going to be guilty of trespass, and as we'll see, that comes with very severe remedies. Secondly, you are subject to the Correlative Rights Doctrine. So what the Correlative Rights Doctrine says is, okay, the rule of capture says go ahead and produce as much oil and gas as you want, even if it's producing oil and gas that was underneath your neighbor's land, and even if you leave your neighbor with nothing left, if they don't get around to drilling for oil and gas. But the Correlative Rights Doctrine says that nonetheless, when you're drilling for that oil and gas, you have to do so in a non-negligent way, a non-wasteful way that doesn't end up reducing everyone's production from that reservoir. So in your course book, you can see an example, this Texan versus Elif case, where it talks about one landowner, neighboring landowners are producing, one landowner negligently produces, causes an explosion, burns a huge amount of oil. Now you can imagine that neighbor saying, well, rule of capture, I can produce it. Whether I choose to just burn it off or sell it, that's up to me. But that Correlative Rights Doctrine says that's not okay because that's negligent or wasteful. You're not just keeping all the oil for yourself and at least you get the economic benefit of it. You are simply wasting it so no one gets the economic benefit of it. So you're not allowed to do things that are wasteful. Now, one challenge, as we'll see, is that in general, you can reduce the recovery from an oil and gas reservoir by drilling too many holes in it or by pumping too fast. But how many is too many wells? How much is pumping too fast? It can be very difficult to define. And we'll see that states will often define how many wells you can drill, how quickly you can pump. And when they do that, in some sense, they're defining what your correlative rights are. You are, under that state law, you have those correlative rights as a neighboring landowner that your neighbor won't drill too many wells or drill and pump oil too fast. And what that is defined under state law. But even without that state laws, there's this background principle of the Correlative Rights Doctrine. You can think about this as analogous to other rules under the common law that say shared rights have to be used reasonably. A couple examples are the obligation of co-tenants, or think about your obligations toward your roommates if you have roommates, or a reasonable use of an easement. You have to use this resource with some regard for the rights of others, and you can't simply use it wastefully, even if you are allowed to produce all the oil and keep it all for yourself because of the rule of capture. Okay, I said you can't drill a slant well. What is a slant well? Well, this is what it looks like. Classic slant well would be what you see in number 1 here. The idea is, okay, you start out drilling down, but then you eventually turn and slant that well so that you're producing a reservoir that's actually on your neighbor's property, and your well actually ends on their property if you follow that property line which goes down to the center of the earth. Okay, does directional drilling change that? Well, look at example 2. The answer is not really. You still, although you can turn horizontally, and we can do that a mile underneath the earth, and we can thread through these rock layers, that still doesn't authorize you to send your drilling bit and your well into your neighbor's property. So that would still be a slant well. There still would be serious remedies available for that kind of trespass. Okay, there is a more complicated case though, and that's what this Briggs case in your textbook from Pennsylvania and the Garza case that's referenced in your textbook, and it's from Texas. That's what those cases are about. What happens when, with directional drilling, you go close to your neighbor's property, but you don't enter it with the well? So your well is turned to the side, but then you fracture that well. And those fractures extend further from the well, and maybe there's a question. In both of these cases in your textbook, there is a question about whether those fractions extend onto the neighbor's land. Now, what I want to ask you is that just a slant well, right? We know that you're not allowed to send your drill bit and actually drill onto your neighbor's property, but what about when you fracture onto your neighbor's property? Is that kind of just like extending that drill bit further into their property? Or should that be covered by the normal rule of capture? Your drill bit didn't enter their property, and you are just ensuring that oil and gas from the full reservoir flows into the well that you drill. And so with a regular conventional well, you would have a pump on that. That pump would lower the reservoir pressure throughout the reservoir, creating a vacuum that would draw oil and gas up to the surface. So you're still changing the oil pressure on their side of the line. It's just that you haven't drilled into their property. Is that basically the same as drilling close to their property, but fracturing to cause that oil and gas to flow up your well? Or is it more like a slant well? And we'll see that that's an issue in both of these important cases, Briggs from Pennsylvania and Garza from Texas. So starting with Briggs, this is Briggs versus Southwestern. It's a recent case. It's from 2020 Pennsylvania Supreme Court. It's on page 54 in your book. It's the biggest recent case on this issue. So Southwestern, the oil and gas company, used hydraulic fracturing to produce gas from a property that neighbored Briggs's. And so Briggs's concern is maybe you're producing oil and gas from my property, underneath my property as well. So Briggs sues for trespass and conversion. They say this is basically like a slant well that you may not be drilling onto my land, but you're effectively fracturing into my land. Now, if you read that case carefully, you'll see that they maybe didn't do a good enough job of alleging that in their complaint, but we'll get to that. So the trial court here said there's no liability. This is like the normal rule of capture. If you didn't drill onto their land, then the rule of capture covers it. We don't have to figure out where all this oil and gas comes from. It all belongs to the person that produces it at the surface. The Superior Court, basically the appellate court here, reversed. And they held two things. First, they said, look, the rule of capture doesn't apply to non-migratory shale gas. Now, that's pretty interesting, okay? By the way, should you be more worried about your neighbor producing gas if it's from a conventional reservoir or from a shale reservoir, or a conventional oil reservoir or a shale oil reservoir? Think about that for a second. In general, it's more of a worry if they're producing from a conventional reservoir, because we know that in a conventional reservoir, there is permeability so that oil and gas can flow back and forth. And so when your neighbor produces from a conventional reservoir, oil and gas is flowing from underneath your property to their well and up to the surface. In a shale reservoir, in some ways, we don't have to worry as much about the rule of capture precisely because this layer of rock is less permeable. So they can't really drain all of your oil and gas. The question in these cases is whether they're draining just the edge of your oil and gas because there are fractures extended onto your land. And what the appellate court here said is that the rule of capture actually just shouldn't apply to this non-migratory shale gas. It is because it's a very different process, and effectively you have to fracture to produce gas from it. Secondly, the court said if shale gas was produced from Briggs land, and that's something that Briggs did allege that gas was produced from their land, then that hydraulic fracturing fluid must have invaded their land, because they said, well, it's impermeable rock, so if you were able to get any oil and gas from their land, it must have been because you had that fracturing fluid creating fractures that released that oil and gas. Well, here the Pennsylvania Supreme Court reverses. They say, look, one, the rule of capture still applies. There's still reasons for it, including that we can't necessarily tell where all this oil and gas came from, but also it's not clear that Briggs has really alleged enough here, because they didn't specifically allege that the hydraulic fracturing fluid had entered that land. And so the inference that the appellate court made, which was, well, if there was oil and gas produced from Briggs's land, then there must have been fluid invading. The court says, well, that's not so clear, because of course there could be a reservoir of medium permeability or permeable areas connected by impermeable areas, and it's possible that fracturing just on Southwestern's land may have ended up producing from a reservoir on Briggs' land, even if the fractures didn't extend that far. How plausible that is, interesting question, but they say, well, look, we haven't done enough to show that here. All right. I want to talk also about the Texas case, Coastal versus Garza Energy Trust, because this has been one of the most important cases over the last decade and a half of oil and gas law, because it happens right when fracking is starting to take off as this huge economic force around the country in 2008. It's from the most important oil and gas jurisdiction, which is Texas. It's on page 68 in your textbooks. You will find a lot of folks talking about it today. In your textbook, it's just discussed in the Briggs case and then discussed in the notes after the Briggs case. But let me tell you a little bit about what happened here. So Coastal, the oil and gas company, planned and executed a fracture that, according to Garza, was designed to fracture onto their property, where Garza just had a royalty interest. Effectively, their only interest in this property was in getting the oil and gas revenues. It was effectively a monetary interest here. Now, one interesting thing is, on that Garza trust land, Coastal was also the oil and gas operator there, because it was the lessee. It was the oil and gas company responsible for producing. So why, you might ask, would Coastal prefer to produce on their own land versus on this land? Well, because that other land was their own land that they simply owned, and so they didn't owe a royalty to everyone. So for perspective of Garza Energy Trust, their concern is, oh, of course you don't want to produce on the land where you owe us a royalty, and so you're producing everywhere else. Okay, we'll come back to that what seems like maybe a conflict of interest in the oil and gas company's operation of these two properties. So Garza sued for trespass. It said, again, these fractures extend onto my property, and so you've entered my property. That's a trespass. and they won in the trial court. And the trial court gave them not just compensatory, but exemplary damages. Those exemplary or punitive damages, that's one of the real risks of a trespass claim. It's why you don't drill a slant well, etc. Trespass is a serious business, and the Court of Appeals upheld that. Here, the Texas Supreme Court reverses, and here's what they say. Trespass against a royalty. They say this is a non-possessory interest. This is just an interest in production from the land, just an interest in oil and money. That requires some actual damage. The only thing you could really recover here is money, and the rule of capture doesn't allow you to recover in this circumstance because the court holds rule of capture still applies. Now, there are a couple other interesting opinions in this case. One is from a concurrence from then Justice, now Judge Willett. He's on the Fifth Circuit. He's a very famous Twitter judge. He says, really, we should have just said categorically this is not a trespass. Just like when we started having airplanes, we said this theory that you own to the heavens and no one can cross over your property, that doesn't work for the modern world, and so we limited the ad coelum doctrine. Says similarly, we have to limit this doctrine because we can't have everybody worried that they're potentially liable for these punitive damages every time they're fracking, especially because we can't tell exactly how far their fractures extend. There's also a dissent, and the dissent says, look, this is just like a slant well, and so this should not be allowed. And what I want you to think about a little bit is two big questions. One is, what protection does Garza still have here? Because remember, it does seem a little bit unfair that the oil and gas company has chosen to produce where they get all of the oil and gas rather on the land where they owe a royalty to the Garza Energy Trust. And as we'll see later in the course, there is an implied covenant to protect against drainage that protects landowners in these circumstances. Now you might ask, well then why didn't Garza sue Coastal under the implied covenant to protect against drainage? Why did they sue for trespass? And the answer is because trespass gets you these huge exemplary and punitive damages. So I want you to understand, it's not like Garza, in this case, would have been left with no recourse. There are doctrines that we'll learn about later in the course that would allow them to protect their interests. They just wouldn't necessarily give them the same access to exemplary damages. Okay, the second thing I want you to think about is, what is the right rule? Is this more like a slant well? Is there some unfairness? Is this kind of ruling going to just encourage companies to go right up to the line and fracture as far as they can into the neighbor's property? Or is this, is this kind of a reasonable decision from the court because they're trying to avoid having to have the courts and juries decide these complicated questions about how far these fractures extend? Keep in mind, and this is something the court emphasizes, the Texas Railroad Commission, which is Texas's oil and gas regulator, still has the ability to say that these fractures have to stay back a certain amount from the property line. The well has to stay back a certain amount, and they have to take certain steps to ensure their fractures don't cross the boundary line. So it still can be regulated, and maybe those regulators are better equipped to make those kind of technical rules versus the court, versus juries. The other thing that you might want to think about is, is this a scenario where it's really important economically that oil and gas companies have some certainty about how they produce? Maybe, what rule do you think would produce more certainty? So this is an area where there's been ongoing debate, as you see from this 2020 case in Pennsylvania. The courts across the country still haven't necessarily come to a single rule, but you see courts in Pennsylvania and Texas, both important jurisdictions, both saying that, at least to some extent, the rule of capture continues to apply even with fracturing. Next case. Let's talk about Peoples Gas versus Tyner. This is sort of the old school fracturing, which was that back in the day, rather than this careful and precise process, not completely precise because we still don't necessarily know if we're crossing the property lines, but back in the day, you just simply dropped explosives down the well, and we knew that could produce more oil and gas. It could produce it for a couple reasons. One is, of course, you could crack up shale or otherwise. Secondly, it could improve permeability, even in something that had some permeability to start. And third, it might access reservoirs that were previously not in contact with the well. So in this case, Peoples wants to shoot the well. That means to cause an explosion. We'll talk about it in a second. Tyner seeks an injunction. Now the question is, can Peoples shoot the well to capture more gas? The court really says two things. One is, if your only plaintiff is that Tyner, is that Peoples is going to produce more gas, that is not sufficient. Because of the rule of capture, they're allowed to do what it takes to produce more gas. However, in this case, they alleged and showed that there would be actual damage on neighboring properties from these explosions, and as a result, that injunction is upheld. Okay, here's actually what, a couple of pictures of shooting. So sometimes you'd see literal explosives dropped down the well, basically a hand grenade, right? More commonly, as you see here, is this nitroglycerin poured down the well, and that's what also was suggested in the Tyner decision. I'm going to read you a little bit from this American Oil and Gas Historical Society description of this and the dangers involved. Applied legally or illegally, by 1868, nitroglycerin was preferred to black powder, i.e. gunpowder, despite its frequently fatal tendency to detonate accidentally. A flame or spark would not explode nitroglycerin readily, but the chap who struck it a hard rap might as well avoid trouble among his heirs by having had his will written and a cigar box ordered to hold such fragments as his weeping relatives could pick from the surrounding district. So, a dangerous process. You can read more about it at the link. Okay, next case. Wronski versus Sun Oil Company. This is a Michigan case from 1978. In this case, Wronski owns land that's in a field that's also drilled by Sun. Now, production was regulated to 75 barrels per day. Why? Well, we'll see there's a couple reasons, but one important reason is to protect the reservoir. Because often if you produce too fast, you can damage the reservoir and you get less overall production when you do that. So here, there's a limit set by the state of 75 barrels per day. Now, Sun violates that restriction, and they say, well, look, no problem, rule of capture, we can produce as much as we want. But you know that in this case, you can't rely on the rule of capture because there's also correlative rights. And so if the state is saying that producing more than 75 barrels per day will wastefully damage this reservoir, then you have to follow that rule. And if you don't follow that rule, it's like a trespass. The rule of capture no longer protects you. So the court here applies the harsh rule rather than the mild rule for damages, just as we've seen. If you trespass and for some reason the rule of capture doesn't protect you, you can be liable for serious damages. Okay, as a reminder, that Correlative Rights Doctrine says that mineral rights owner has that duty to other owners to exercise the right to capture in a non-negligent, non-wasteful way. And conservation laws, if you violate one of them, like was done by Sun in this case, that may be a per se violation of the Correlative Rights Doctrine. And so then we see this harsh rule for damages. Okay, last case for today, Champlin versus Western Bridge. This is a case from Oklahoma in 1979. It's on page 83 in your books. This is a case of somebody maybe taking the rule of capture a little bit too literally. So Western Bridge owns these surface rights that are adjacent to Champlin's storage of refined oil products. We've talked about how oil is so dense, and one of the benefits of that, all the energy that can be stored in it, is that you can store that oil for when you need it. And that helps to smooth out oil prices, because if there's a real spike in prices, you can use some of that stored oil. So that's a huge benefit. Well, here, Champlin was storing it, but their petroleum storage leaked, and that oil ran downhill onto Western Bridge's property. Western Bridge said, aha, rule of capture, here comes oil across my land, I'm going to gather it up and sell it. The court says, no, you're not allowed to do that, because this isn't like a wild fox that ran across your land. Champlin had already done all the production. It had already stored this. It may be liable to you for damages for damaging your land, but this isn't like you found this wild oil and gas in nature. It had already been produced by Champlin. And you can think about this decision as kind of analogous to this principle in the common law of animus revertendi, which says, if there's a wild animal that's captured, if the fish jumps out of your net, well, you can't collect it from the fisherman who later catches that fish. Same thing with a fox. If you catch it for a little bit, but then it escapes, it belongs to the next person that catches it. On the other hand, if you have domesticated that animal, if you domesticate that fox and then it escapes, well, okay, then it may belong to you. Or if you've done something, you put that fox in a zoo, you removed it from its natural habitat, and it escapes the wild. No, you can't just claim the tiger that escaped from the zoo and says it belongs to you under the rule of capture. So there's this background principle that if you have done something to really take that product out of the state of nature, make it your own, either domesticate it or put it somewhere that you can put it to use, then all of a sudden it belongs to you, and the mere fact that it escapes doesn't allow somebody else to take it under the rule of capture. That applies equally to this dispute between Champlin and Western, and so you can think of that as animating the decision here. So with that, that's the rule of capture.